to Bodacious Estate Conversations, the podcast where we skip the polite small talk and get straight to the real story about handling a loved one's property. From unexpected challenges to the messy emotions nobody warns you about, I bring you unfiltered stories, practical advice, and clever shortcuts from people who've been there and the professionals who know the way. If you want honest answers, bold strategies, and the confidence to take control, you're in the right place. Here is your host, Casey King.
Thanks for tuning in to Bodacious Estate Conversations. Today's episode is one I think a lot of families are going to be able to relate to, because we're talking about what happens when an estate includes more than just a house or a bank account. What happens when someone inherits a business? And even harder, what happens when siblings disagree about what should happen next? Stick around until the end, because Frank is going to share some of the biggest mistakes families make when emotions, inheritance, and business ownership collide. That's right. And what can be done to prevent those conflicts before they destroy your relationships. Joining me today is Frank Sullivan, Senior Counsel with Hill Wallack LLP, where he leads both business and commercial and trust and estate practice groups. That was a mouthful. So Frank has extensive experience helping families, family-owned businesses, partnerships, and individuals navigate succession planning, estate issues, ownership disputes, and business transitions. Frank, I'm so excited to have you on the show today. Welcome.
Thank you, Casey. It's a pleasure to be here and delighted to speak to you and to everybody that might be listening.
I love that. Okay, so let's just dig right into it. So Frank, most people understand inheriting a home or, financial accounts, but inheriting a business is a completely different situation. When a business owner passes away, what are some of the inherited issues families and executors usually face?
Well, the biggest problem with inheriting a business is who inherits and whether or not there is going to be any conflict within the family as to who's now going to operate the business. And, you almost have to go back to the business owner before they pass on to kind of tell them. It's almost like listening to Ebenezer Scrooge in the Christmas Carol. The things that they should have done before they died, where now it is an opportunity to rectify it. And the opportunity to rectify the family dynamics is before the founder of the business dies. Because otherwise what happens is that there's conflict within the family, who's in charge, what should be done, who's to do it, and obviously the issue of compensation and so forth. The other real problem oftentimes that I see is when you have a number of owners of the business, you have founders, 2 or 3 guys get together, which I've had that experience with, and I sit down with them when they say, hey, we want to start a business. And I say, that's great. What kind of business? Oh, we all do this, we all do that, and we're coming together because together we're stronger than we are individually. So I sit down at the table with them and I say to them, okay, that's a great idea. Now let's talk about some horrible things. One of you guys is going to die. And not only that, we don't know who's going to die. When, we don't pick the day and the hour. It happens. And so I'll turn to them and I'll say, Tom, do you want Joe's wife to be your partner? And he'll say, oh, I love Joe's wife, but I don't want her as my partner.
Yeah.
And I'll begin with that, saying, okay, well, we need to talk about, we got to begin with the end in mind. Because sooner or later, something's going to happen. And now you guys are, quote, all in love and you want to do this thing and you want to join forces and make this a successful business. Well, making a successful business requires planning. Not only in terms of the business itself, but in terms of how you're going to pass the business on. And when you have members or founders or, 1 or 2 or more, or even if it's just one individual, you got to be planning on what happens when the founder is no longer able to operate the business or dies. And you can get hit by a bus anytime. And the question really then becomes, the family dynamics. And you need to talk to the family, because I've seen situations where the business gets passed down because all of a sudden the founder dies. And not to be sexist, but in my experience, it's always been more of the men. Now, in terms of women plan. Sometimes men don't.
Yeah, I could see that.
And
Yeah.
you can talk
see that.
more easily to a woman entrepreneur about her exiting the business than you can with a man, because they're too busy thinking in their own mind as to what they've got to do to make the business successful. Well, success also means being able to pass it on. That's why you don't see too many businesses successfully going to the next generation. And that's simply a matter of the lack of preparation and having that event occur. So succession planning now is a very big thing in the business world and in the professional and the legal profession. Having these very hard conversations, and they are hard. When you tell somebody that they're going to die, and they're going to give they are involuntarily going to give up everything they worked hard for. It's especially for men. It's more difficult to have these conversations because you then have to face your own mortality. From a legal point of view, there's also a problem with the attorney in speaking to the group of individuals forming the business, because you have the attorney-client privilege. So I always have to say to the other members, the founders, if there's two or more, you each are entitled to go get your own independent counsel to determine what it is that you want to do. And then we can get together, and depending upon the type of entity, whether it's a corporation, typically most corporations elect to be S corporations, which means that all the income and the losses are passed down to the owners on an individual basis. Or if it's an LLC, a limited liability company, then everything they're called pass-through entities, so that the financial operating results pass down to the owners. So you have to make sure that they all understand their risks and obligations and duties and liabilities, and then you try to synthesize all of that into some type of an agreement, an operating agreement if it's an LLC, or if it's a corporation, an S corporation, a shareholders agreement.
Yeah.
And that's the document by which everybody has to live by. So it's important to talk about the horribles that can occur in the event one owner should no longer be able to operate and or they die. Death is a specter that is in every business operation. Every entrepreneur has to understand that they need to plan for that inevitable, not possibility, but that inevitable potential that they're going to die. So that becomes a real issue.
I love that. So I know, all of your experience, you've worked with a lot of family-owned business over the years. Why do business assets tend to create so much conflict between the siblings or the heirs?
Well, it's any family dynamic. It's not necessarily a business, but in any family dynamic, you're going to have naturally occurring conflicts between the siblings. If you're an only child, you don't have those issues. But if you've got two or more siblings, then the question becomes, do the siblings like each other? Can the siblings get along? Do they respect each other? Are they willing to go in the same direction? And oftentimes that's not the case. And many times siblings have fundamentally different interests. You might have a sibling that is more artistic or is more inclined to do things that are contrary to, or not contrary, but are different from the interests of another sibling.
Right.
And when you get a situation where the founder of the business dies, and has not done the appropriate planning, and fails to have a will that takes into consideration the dynamics of the business and the estate of the individual, then if they all have an ownership interest, you automatically have a conflict. Who's in charge? Who's going to do the operations? Who's going to take care of the business? And you'll have siblings that say, I'm not interested. Let's just go sell the business. And then the operator, the one who's been perhaps involved in the business, doesn't want to do that. So and that sets off a whole series of conflicts, which could end up in litigation. And I've been in a lot of litigation between siblings. And invariably, the only solution is to have one sibling buy out the other siblings, or one or two buy out the other one, and then that becomes an issue of, does the business itself have the ability to sustain the financial cost of buying out another individual? And oftentimes, what happens is that the individual that gets bought out, they're the ones that win, because the business now gets loaded with debt.
Oh.
And the operators have to then make sure that they can pay that debt. Whereas the sibling that got bought out, they're often doing their own thing with the pot of money that they essentially force their siblings to pay in order to get them out of the business.
Wow.
So, or the only other solution, and this is also a real life solution, is that they get together and say, all right, we got to sell the business. And then that has the impact of devaluing the business, because it's everybody begins to understand that the siblings aren't getting along and they got to sell. And that's when the sharks come out.
Yep.
And they start, they lowball the business. Or if it's the type of a business that relies upon service, well, that business can just walk away. So if you have a business, let's say, to make it easy, it's if you have a business where an electrician, you have the electricians, the owners, the siblings can't get along, they decide, let's sell the business. Well, then everybody understands the siblings don't get along, and the people who would use their services simply go to some other business, and the value just plummets. And it's simply because there's been no planning, and the siblings can't get along. That's where a good shareholders agreement or operating agreement that outlines what happens if. And there's a couple of things that can be done, especially with, again, getting back to death. One of the ways in which you can create a fund to buy out that one sibling that is not interested is to have life insurance. And the life insurance gets paid either to the business or to the siblings, and in many cases to the surviving spouse, to help buy out their interest. And that then doesn't create a debt to the company because you have life insurance. Now, obviously, you have to buy the life insurance and you got to pay the premiums. And there's a couple of different issues with regard to that. But by and large, that's the panacea that takes care of the issue where you've got a entrepreneur, a founder, and he's got several siblings. His spouse may still be alive. And what happens? And how do you fund it? So I hope that, and that happens every day. That happens every day.
That's so interesting to me. Could there be a solution where the sibling that doesn't want to take ownership in the business, it just becomes a silent partner within the operating agreement and gets paid, a stake, just say, hey, we're going to continue this business. You're not going to be involved in it, but we'll pay you based off of, how well the business is doing.
Well, that's a solution, but it is an answer. It's perhaps not a good solution. I've been involved in cases where that has occurred, and the sibling or the even where you have two or three owners of the business, one dies, and one, you have an owner, one of the people that own it they're not pulling their weight. So just imagine having a sibling that's not interested in the business, and all they want to do is be paid. So, and under Pennsylvania law, if they become an owner of the business, a shareholder, they have the right to be given certain information. They have a right to see what the financial position is and who the shareholders are and so forth. So one of the issues with just paying the sibling is the sibling can become a thorn, can become a problem, because they're only interested in money and they're not interested necessarily in the ongoing health of the business. And if the business has a hard time, they're in a financially difficult position, or something happens where the revenues aren't as great as they had been, then that person's not going to be interested in taking a pay cut. They're going to complain. And I've seen circumstances where the disaffected, non-operating or non-involved sibling says, well, I'm going to go get a lawyer and we're going to dissolve the company. And the Pennsylvania law does not allow a sale or a forced sale. Other states do. For example, New Jersey, you can do that. But Pennsylvania, the bottom line is that when you get involved in litigation, the only real resolution is either to buy that person out, and then you have a problem with regard to how much they want and what impact is that going to have on the business, or you have to sell the business. You dissolve the company.
Well, I think that's good that you can't force a sale. But how do you evaluate how much the business is worth to determine what would be fair to buy a sibling out?
Well, you have to evaluate the entire business. And there's a number of companies out there that do this, they value the business. And oftentimes, again, getting back to my initial meeting with the three founders who want to get together to start the business, in addition to talking about what happens if one of you dies, in that conversation or during those conversations, I'll ask, who's the accountant? Because many times the financial operations and the accounting has to be well done. So you need an accountant that not only is able to do the debits and the credits, which in many cases, that's all the accountants do. They take the information given to them and they regurgitate it back. A good accountant is somebody that can become a real assistant, a real provider of service to the business by helping them with respect to the ongoing operations and the financial results of those operations and what they should or shouldn't be doing from a financial point of view. But a good accountant can also help with the valuation of the business, because when you value a business, you look at its assets. And again, in a service business, very difficult to value the business, because in many cases, the business valuation is a function of the individual who provides the services. So, in a law firm, for example, it's very difficult to come up with a hard value if it's a small firm and the clients like to deal with Joe or Tom. But if Joe or Tom are not there, they walk and they go somewhere else. So in a service business, it's very difficult to get a real hard value. It's hard to sell.
Frank, a lot of people don't realize when they inherit a business what their responsibilities are going to be, and if there are any liabilities involved in it. So from your perspective, what should executors understand about inheriting a business and what all it includes?
That's a very difficult question, and it creates all kinds of real life problems. Yeah. Again, assuming that the individual has failed to do the proper planning. And when I talk about planning, not only does it include planning for the succession of the business, but also the estate in the form of a will or trusts and things like that. They all have to be integrated if there's going to be a successful transfer of the ownership interest and to maintain the value that gets transferred to the estate. Fundamentally, once you become an executor and you, assuming that there is a will, a last will and testament, that will then get submitted to probate. And under the terms of the will, there'll be an executor or executors who are appointed. Once the will is probated, the executors take an oath to well and truly administer the estate in accordance with the terms of the decedent's will. And if the will says, I give my estate, or what they call the residue, to whom they name in their will, then the executor has an obligation to transfer the assets or the value of the assets to those individuals. The executor assumes the liability to make sure that, first, all the creditors of the estate are paid, and secondly, that they follow the terms of the will. Because what happens, and this happens many times, again within a family context, where one of the beneficiaries believes that the executor has failed to follow the terms of the will or has wasted the assets in the estate, and they bring an action against the executor to sanction them and to have them pay damages. So the executor is in a position, once they become the executor, because they're the only ones that have the authority to handle the estate functions. They're the ones that are supposed to pay the bills, pay the creditors, and then transfer the assets of the estate to the beneficiaries or the value of those assets. If you've got a business and the executor is not the one operating the business, then that becomes a concern, because the executor may not know what to do with the business. Typically, if it's a situation where you have the founder makes a will and then says, I give everything I've got to my spouse. Well, the spouse may not have ever been involved in the business. And at that point, the value of the estate is in jeopardy, because if the spouse doesn't have a management team or managers that can keep the business going, the business is likely going to have to be sold. And again, at that point, it becomes a distress situation where the value of the business can significantly be diminished. The appointment of an executor is something that is often overlooked in terms of its importance. And if you have executors, if you have more than one executor, and oftentimes in a family, the husband and wife will say, well, we've got 3 kids and we don't want to slight any one of them, so we'll make all 3 of them the executors. Well, that's a recipe for fighting, because unless those 3 get along, they're not going to be able to get along as executors.
Yeah.
And the executor is the one, and the executors are the people that operate the estate. So the determination of who your executors are going to be is very important. And it's important that not only do they have the business acumen and the financial acumen and an appreciation of their obligations, that creates conflict. And when you have conflict, you have litigation. And I've been involved in dealing with estates where there's a lot of money and everybody lawyers up and everybody files actions against each other. And what happens is that the value of that estate is diminished because there's the cost of legal fees and there's potential damages. And it just is not it is not a situation that either mom or dad or whomever, the founder, ever anticipated. And one of the real dynamics that occurs in a family, once the individuals who kept the family together are gone, then once mom and dad die, the willingness to continue on in a cohesive, cooperative manner often is lost. You can imagine oftentimes where one parent says to the kids, you've got to do this. You got to get along with your brother. You got to get along with your sister. Don't argue, just get it done. Once that control is gone, then there is unlimited ability to just argue and get back at each other. Once parents go, then it's an opportunity for siblings to prove to the other siblings that mom and dad really like me better than they liked you. And you get, I'm involved in estate litigation now where you have an overwhelming sibling, a sibling that has always been, quote, the boss. And now that the parents are gone, the rivalries come out and they go after the boss, and then the boss goes after them. And we're just mired in litigation. And you go in front of a judge, and the judge's attitude is a pox on all your houses. And this is what's going to happen. And you lose. If you got to go to a judge in the orphans court, and the judge has got to make a decision, nobody's going to be happy. So it's important when you appoint your executor that everybody understands the position of the executor, and they're the ones that control the estate. And that they need to understand that their job is as a fiduciary. Their obligation is as a fiduciary to make sure that the wishes of the testator, the person who is deceased, that they've got to follow their will. And if there's not a mistake, but if they don't provide for the succession planning, that is a real problem. And there's ways in which you can get around that, not to get around it, but things that the individual can do during their lifetime in terms of setting up trusts, setting whether they're revocable or irrevocable, whether they can put assets in those trusts, name a trustee, and provide certain guidelines as to how the trust is to be operated once the individuals pass on. So there are mechanisms to resolve that, but it takes planning. And planning is the key. And unfortunately, things can happen before the planning can be done. People get sick and die. People get unfortunately killed in accidents, or they lose their mental capacity. They no longer have the ability to understand what they should or should not do. And that's another issue. But that's in terms of the executor. It's a real. It can be categorized as no good deed goes unpunished. Being an executor, or having co-executors, can become very, very difficult in getting things done for the estate.
All of that being said, obviously, like, planning is the key, making sure that you have everything planned prior to, crisis happening. But I wanted to switch gears a little bit here because you've had a really interesting career path. I mean, you've done business law, estate law, taxation, mediation, Chapter 7 bankruptcy, trustee. So just like with all of your experience that you have, what originally drew you to this line of work?
That's an interesting question. I've been at it. I've been practicing law for 50 some years. And as you said, I've had a wide variety of experiences in the business world. So I kind of know business when it's going up, when it's successful, and I know business when they're coming down, when they're not successful. The bankruptcy situations are particular relevant to when a business goes down. One of the things that always drew me to the practice of law was that it first provided for me, and a lot of people say this when they're young and they're in college. I want to help people. Okay, but you don't know what that means. Helping people is really kind of a very broad concept. So I early on thought of, well, if you really want to help people, how are you going to help? How can you help people? And I found that the idea of being an attorney, where you can help people and you can counsel people and you can help them in their darkest hours, it had a real appeal to me. But I didn't know what type of an attorney I was going to be. You go to law school and you study all kinds of areas of the law, from contracts and torts and securities law and things of that nature. You get out of law school, you join a firm, and all of a sudden the partners in the firm say, you're going to do this. Well, it turns out that the area of law that you are engaged in over a long period of time really picks you as opposed to you picking it. And if you're fortunate enough that you like what you do, then you can be successful. Because a lot of attorneys get burned out because they don't like what they do. And they're doing it because they've got a position or a job with the firm and they're being told, you're going to do this. And they don't necessarily like it. And the only way they can do it is change firms or get out of the profession. So oftentimes you'll see a lot of people who have a degree and a JD degree who are involved in anything other than the practice of law. So that's a long way to answer your question.
Interesting. So after over 50 years of practicing law, what do you think keeps you passionate for all this time?
Well, it's the same motivation. I mean, it's the ability to understand people and not only answer questions, but ask them questions to get to the number of all of their issues. So when someone comes in and they want to have a will, you can't just sit there and take information. You've got to ask a number of questions, and then after you have asked the question, you have to sit back and listen. Good lawyers are the ones that can listen. Mm-hmm. And hear what their clients are saying. Mm-hmm. And you then have to ask questions and probe what they've said to you. It's not unusual to be sitting in a meeting with clients and you ask these questions and all of a sudden you find out you've hit a nerve and they start to cry. Oh. And you have to deal with that. You have to deal with those emotions.
So I imagine when, most people think about attorneys, they picture contracts or courtrooms, but it's so human, what you're doing. I mean, have you found yourself acting as a counselor during most of these sessions?
Yeah, initially that's true. And it's if you're a counselor, because attorneys, when I look at somebody's letterhead, I say to the younger attorneys in my firm, you're more than, the word lawyer and attorney are interchangeable, but I prefer attorney because you're an attorney and you're a counselor at law. And the ability to help people is you have to counsel them. But in order to do that, the first thing you've got to establish is trust. Mm-hmm. If they don't trust you, mm-hmm. if they don't believe you, if they don't feel like you understand their particular problem, you're not helping them. And you're not doing what lawyers, attorneys are trained to do, and that is to listen and to help their clients. Now, the other side of that is that it's a profession, but you have to be paid for your personal services. And that sometimes it itself creates a conflict. There was a New York Times article with the cartoon, and there's a situation where the cartoon has an attorney sitting behind this big desk, and the client is sitting in front of the attorney, and the attorney says to the client, "Mr. Smith, you got a great case, but it's going to cost you more money than it's worth. You have to, you have to discuss economics of the practice." So as an attorney and counselor at law, you hear their problems, you have to tell them, they have to trust you, and you have to guide them on how to resolve their issues. And it may not necessarily be what they want to hear. And then you say, and by the way, this is my hourly rate, and we require a retainer, and so forth and so on. So it almost is contradictory that they're trusting you with their problems, and now you got to pay for it. So that's the way it goes.
I could see that. So when you're not helping your clients or mediating or doing all of the many things that you do, what do you enjoy doing outside of the office? How do you spend your time?
So, I'm very, very busy outside of my working hours, dealing with my family first, and then with my community of attorneys, or my community in which I live as a member of nonprofits, as a member of a nonprofit. So I've got a lot to do. My time is always occupied one way or the other.
I love that. Keeping busy, staying busy. So Frank, if somebody's listening today, just inherited a business, biggest piece of advice that you'd want them to remember?
They need good advice. They need good professional advice from an experienced attorney who has suffered the slings and arrows of outrageous fortune, has had any number of experiences, both good and bad, so that they can help their client navigate what they have to do with the estate. Oftentimes, there's so much that has to be done in the beginning. There's all the procedural matters that have to be followed in order to probate a will, or if there is no will, to have an estate administered under the Pennsylvania intestate laws. So there's a lot of upfront work that has to be done. But after that is done and the estate is established, then you got to figure out what to do with what the contents or the assets of the estate are. And you have to follow the will. So a lot of that becomes important in the beginning. And then you have to carefully advise the executors as to their obligations under the will and what they need to do. And it may be from getting the business valued to dealing with the transfer of assets. I just had an estate where the principal beneficiary lived in Germany. And how do I get these assets? And it was primarily a lot of paintings and dealing with a lot of tangible items that needed to be shipped over to Germany. And then, and this is something that a lot of people don't necessarily think of, but when mom and dad die, the history of the family is oftentimes captured by photographs. And now we have everything on our cell phones, but how do you be able to transfer for the next generations who the ancestors were, who mom and dad were? And oftentimes that is in photographs. So one of the things that I tell my executors is that if there's a lot of family photographs, you make copies so that everybody can get those photographs, because everybody will have their family and they need to pass on those memories to their children. But that's, you in the beginning, you have to spend a lot of time with the executors, with the clients, and find out what it is that they have that need in the estate and what has to be done with the estate. And if it's a business, then you need to understand, does anybody else have an interest in the business? And what's the best thing to be done with that business in terms of making sure that the value of the business is transferred to the beneficiaries under the will. So like if you have a will where it says everything goes to my spouse and the spouse has never been involved in the business, then you're essentially you as the attorney ended up in a way operating the business. We had an estate where the individual died. His spouse had predeceased him, but he owned 4 businesses, 2 of which consisted of a lot of real estate. So we ended up dealing with the operations of the business portions of it. He had a finance company. We had to operate the finance company, and then we had to go through and get all of the real estate sold in order to get the assets passed down to the named beneficiaries. So oftentimes an attorney ends up de facto operating business and preserving its value to pass on to the beneficiaries. So it's as long as it is broad in terms of what the asset mix is. If there's a business involved, it becomes much more complicated, especially if there's been no planning done by the decedent as to what he wants or she wants done with the business when they pass on.
Yep, I can see that. So this is so much fun. What is the best way for folks to get in touch with you if they wanted your help?
The communication. They have to engage in some type of communication. Call me, send me an email, and then we can just talk. I usually like to talk to new clients on the phone to kind of get an idea what they want, and then we set up a meeting, and we then go through the steps of dealing with what the executor or what the client has to deal with in the resolution of the estate. And today with the technology, many times we'll have Zoom meetings, Teams meetings, where before they come in, we can have a face-to-face. Because I've always found that I want to meet my clients in person at some point along the continuum, because they need to see my face. I need to see their face. They need to understand how I operate, and I want to see how they operate in terms of, can they trust me? And from an attorney's point of view, can I trust them?
Sure.
So
I love that.
It's a two-way street. So that's the easiest way to get a hold of me.
Frank, thank you so much for being here and sharing all of your experience and insight with us. You are a wealth of knowledge. I know someone dealing with family, business, inheritance, conflict, all the things. Please share this video with them. Sometimes the best thing a family can do is to just have the conversation before a crisis arrives. All right. Well, that wraps up another episode of Bodacious Estate Conversations. Thanks for listening. We'll be back with more great stories and tips soon.
Bodacious Estate Conversations isn't just chatter. It's about learning, taking action, and finding solutions that actually work. If today's episode resonated, share your thoughts, subscribe, leave a review, and pass it along to someone who could use a hand. More stories, smart strategies, and practical guidance are coming in the next episode. Don't miss it.